Good morning. Welcome to our webinar today. It's on your guide to Maryland estate planning, what every resident needs to know. My name is Eric Brotman, and my co-presenter is Helen Smith. Helen, I'll let you have first shot at giving an introduction for yourself and your practice.
Thank you, Eric. Good morning, everyone. My name is Helen Smith. I am an attorney in the wealth preservation group of Pest and Cats Law. I have been working in the trust and estates area for over 20 years. I'm not going to give an exact number because that just gives my age, and we don't want to do that. I have seen all kinds of changes over the course of the time I've been practicing, especially in the estate tax area. As far as my practice, I work with individuals, I work with couples, I sometimes work with whole families to set up estate plans that make sense. I do simple wills for people who don't have a lot and just need simple, basic wills. I do complex wills for people who do have enough money to be concerned about estate taxes and trying to save and preserve assets, which is what we're going to be talking more about today. And I also do various types of trusts. I advise clients the best ways to minimize their estate tax burdens. I help families administer estates and trusts after a loved one passes away. And we also, in our firm, do prepare federal and Maryland estate tax returns. I also do some other things that may seem like they don't go along with that. I do help with uncontested guardianship proceedings, and I also do work with pre and postnuptial agreements, which again is a way to preserve and protect assets. And so that's kind of a snapshot of what I do in my practice area. One of the first things I did starting out was administer estates and trusts and prepare estate tax returns. And back then we did a lot more of them because our shelters were much lower 20 plus years ago than they are right now. Eric?
You almost slipped up and told us how old you are, which
Oh,
I won't let that out of the bag. So you're a tough act to follow because you're a busy lady. My name is Eric Brotman. I am the CEO of BFG Financial Advisors in Lutherville, Maryland. I've been in practice over 30 years, 32 to be exact. Although I started this firm 22 years ago, and we now have clients in 37 states and are managing almost $1 billion for families across the United States. I'm also an accredited estate planner, which is why this is sort of my bailiwick. I really like to help clients not only figure out their legacies and to do philanthropic planning, but also to make sure that there aren't any hiccups or mistakes or unnecessary taxes along the way. And so we're going to talk a lot about that today. Today's presentation is Maryland focused, although some of it will be general in nature. And just this, because of my financial side of this conversation, Helen's going to give the legal take. I'm going to give the financial take. But this program is not only for ultra wealthy humans. This is for folks who are looking at any stage, adulting, and needing to look at some estate planning. So with that, let's dig in and get started. And starting with taxes is always uplifting, but let's do that.
nothing would please me more than to start talking about taxes. And I think when we talk about the Maryland estate tax, even though we are focusing on Maryland, I want to start with the federal estate tax and how the two kind of work together. For example, when we prepare a Maryland estate tax return, similar to what your income tax returns look like, if you're familiar with those and you look at your income tax returns, which some people don't, Maryland's form piggybacks on the federal form. So when we have a client who only has a Maryland estate tax, we still have to prepare the federal estate tax form and file that along with the Maryland form only to Maryland. So that's one thing. So the federal government and Maryland both have an estate tax regime, and they used to be very together. We used to call them they used to be coupled, and now they're uncoupled. And what that means is Maryland shelter is only 5 million, and the federal shelter is close to 14 million, and next year it's going to be 15 million. The federal shelter has traditionally, over the past several years, increased as a part of inflation. So every year we have a different shelter amount, and I have to try to remember a new number. And and that has continued. Maryland's is flat. Maryland stays at right now, it's been 5 million for quite a while now, and it isn't adjusted for inflation. So Maryland's is 5 million, and there was some talk about dropping it recently. There, it may come up again. I can't predict the future on, on that. But so the federal government not only has an estate tax has an estate tax, a federal estate tax. The federal government has an estate and gift tax, meaning that if your shelter is, I'll go to next year's number, 15, because it's a nice round number, well, kind of round. 15 million is your let's say for next year, your $15 million shelter. If you make a $5 million gift, you have used 5 million of your 15 million shelter and you only have 10 million left. Maryland doesn't work that way. Maryland does not have a gift tax. So if you give away 5 million in Maryland, you still have a $5 million estate tax shelter when you die. And that is something we'll cover in a lot more detail later. But I just like to point that out at the beginning because that's one of the big differences between the federal regime and the Maryland regime is that Maryland does not have a gift tax. So that it does present some opportunities for saving Maryland estate tax um, down the road by making some gifts, which again, I'll get into that more later. Um, Maryland has a $5 million shelter, and Maryland's tax rate is 16%. So anything above $5 million gets taxed at 16%. If you have a $6 million estate, that means your estate would be paying $160,000 in estate tax because it's only the 16% only applies to what's over the $5 million amount. We usually call it a shelter amount. It's the amount that's free of tax before the estate tax kicks in. The Maryland, unlike many other states, also has an inheritance tax. And people get upset about that because why do we have two taxes and a lot of other states only have inheritance tax or estate tax and not both? And there is one thing to keep in mind, even though we have both taxes, Maryland doesn't collect both. Maryland collects the higher of the two. And so what that means is that if you do have an estate that's subject to both taxes, your estate will pay the higher of the two amounts. It won't pay both inheritance tax and estate tax, only it will be limited. So the inheritance tax also is different in that it applies for any amount over $1,000 that's being left to the class of beneficiary, the taxable class of beneficiary. What I mean by that is that if you're leaving assets to children or to a spouse or to grandchildren, those are considered lineal descendants who are not subject to the Maryland inheritance tax. The people who are subject to the Maryland inheritance tax are people who are further removed. Um, you're, if you're leaving assets to a niece or a nephew, nieces and nephews are subject to the Maryland inheritance tax. If you're leaving assets to a friend, those assets are subject to Maryland inheritance tax. Until recently, if you were leaving assets to a domestic partner, you would pay inheritance tax, but that has changed. There is a way to avoid Maryland inheritance tax now. If you're an unmarried couple who um, considers themselves domestic partners, you can register as domestic partners and avoid inheritance tax. So what that and the Maryland inheritance tax is a 10% tax, but it doesn't have there's no shelter amount. There's no and a lot of people get this mixed up. They think 5 million nothing under 5 million is going to be taxed. When you're leaving assets to a niece or a nephew, if you're leaving maybe a bequest of $20,000 to a niece or a nephew, that is subject to the 10% in Maryland inheritance tax. It doesn't matter the dollar amount, it just matters what their relationship is to you. And so, if my example that I gave before with a $6 million, that let's say you have a $6 million estate and you're leaving everything to a niece or a nephew, that would be a 10% tax on $6 million. That would be higher than what the Maryland estate tax would be on the $1 million that's over the $5 million Maryland shelter. And in that example, if you have a $6 million estate and you're leaving $6 million to a niece or a nephew, you would pay the inheritance tax and not the estate tax, because the estate tax would be less than the Maryland inheritance tax that gets paid. And on the actual estate tax form with Maryland, if you've already paid the um, inheritance tax, you can take that as a credit. Your Maryland estate tax amount would show as zero, and you wouldn't make a payment when you filed your estate tax return. You would still have to file the return because you still do have a filing requirement. Your assets are over 5 million, but you wouldn't pay any tax. However, if you haven't paid the inheritance tax yet, you would pay the comptroller the 160,000, and then when you file your estate paperwork later, you would ask the comptroller to pay the register of wills the 160,000 that you paid to the comptroller. So there's different kind of minor tricks that you probably really don't care about right now. But it's important to know that you don't pay both, because I think that does get lost a lot in our talking points when we hear people saying, well, Maryland has two taxes, they're really horrible. And yes, Maryland does have a lot of taxes. I'm not going to argue with that. But in that regard, we have two taxes, but you don't pay both. Um, Also, one other thing, a lot of people talk about moving out of Maryland to avoid the Maryland estate tax, and that is something that can be done. If you're not a Maryland resident, you are not subject to Maryland estate tax unless you own real property in the state of Maryland. So if you're someone who owns property in both Maryland and, let's say, Delaware, and you've decided to move you spend more time in Delaware, you've become a Delaware resident. But if you keep your Maryland house and you still own it when you die, and your estate is over the Maryland filing threshold, you do still have to file a Maryland estate tax return for your Maryland asset. So that isn't, you're not going to have the same um, exact um, requirement. You're not going to pay Maryland inheritance tax on all of your assets. You're going to pay the Maryland inheritance tax on your Maryland real property only. And there's some tricks to trying to minimize and avoid that as well that we can talk about in a little bit. But first, I want to make sure I give Eric some time to talk, since I've been
Well,
running around.
Well, that there's nothing uplifting about any of that, Helen, actually. This is, we shouldn't be doing this over coffee. We should be doing it over bourbon. Maryland is the only, I believe, state now that has both an estate and inheritance tax. There are a number of states that don't have either. And
Mhm,
so that becomes a real opportunity, and there are people relocating
mhm,
for tax reasons. I've often been told that the tax tail shouldn't wag the dog, and that
mhm,
realistically, that's not the only reason one should relocate. However, there are certainly situations where that becomes a reasonable plan. I will say, when we're talking about the upcoming tax landscape, the federal government in the OBBB, which passed earlier this year, did get some clarity on estate taxes now, although to suggest that this is forever is foolhardy, because every time there's a new administration or a new Congress, this is one of the levers that gets pulled. So, estate planning isn't something that you do and you stick in a drawer and you don't pay attention to. It's something that has to be managed like an asset or like any other contract. I will say that Maryland specifically is, because of Maryland's outrageous deficit, I do think that we will see this being an easy lever to pull, and that Maryland will look to essentially tax families at a lower rate, or not a lower rate, but at a lower level relatively soon. I'd be shocked if that's not in the next legislative session, because it's low hanging fruit. It's relatively
mhm,
easy to go after. So I do think there's some strategies that need to be deployed here. One of them is certain forms of lifetime gifting, and you alluded to that earlier. One of them is ways to structure assets so that they're outside of your estate, and we'll talk about that a little bit. There are
mhm,
things that financial advisors, tax advisors, and lawyers can do to preserve and protect some of your property from this type of taxation. These are legal strategies. We're certainly not advocating doing anything unlawful, but there are legal strategies that can be used, and frankly, they should be used because it doesn't make sense to pay anything that you can avoid legally. So I'm going to leave it at that. The business owners, if you own a business in Maryland, as I do, if you own real estate in Maryland, as I believe we both do, Helen,
Mhm.
we're going to be included in that particular regime, at least on some level. And at that point, it becomes paramount for us to not only plan for where we're going to spend our retirement years, potentially, but also on where and how we're going to own property. So that ultimately is one of the things to talk about with your legal, tax, and financial team. I want to jump ahead to a couple of the details here, and without getting into too much minutia, because the last thing I want to do is have people feel tense coming out of this. There are some challenges. There are some things that we can do to plan for this, but there's also some confusion around what is an exemption versus a credit versus a deduction versus a and just like with personal income taxes, there's a language of its own that sometimes I think CPAs make up because they
Mhm.
speak it and the rest of us don't. So let's talk a little bit about some of the things that we need to know, not just at death, but things we can plan for while we're alive. And I'll give you a first shot.
Okay. So the I usually refer so the exemptions, there are certain things that are not subject to the estate tax. But first let me kind of explain what is. So when we talk about the word estate in my practice area, we cause a lot of confusion because estate can mean your probate estate, which is anything that you own in your own name at death that has to be administered and supervised, court supervised probate administration. That's not that's not the term estate that we're using when we're talking about your estate for estate tax purposes. When we're talking about your estate for estate tax purposes, that does include joint assets, which are not subject to probate. It includes assets that have beneficiary designations. Again, those assets are not subject to probate, but are included in your taxable estate for estate tax purposes. You have assets that, if you own life insurance on your own life and you die, life insurance is included in your estate for estate tax purposes. But that is also one thing that can be outside of your estate for estate tax purposes if you plan correctly and someone else owns the life insurance on your own life, which could be a trust owning the life insurance. So that's something that wouldn't be included, wouldn't be taxed potentially if you own it correctly. Your estate tax shelter is also sometimes referred to as an estate tax exemption, and that is the 5 million I was talking about at the beginning of my talk when I was kind of going over the overall rules. And those are the amounts that are, if you own under those amounts, you are not going to have to file an estate tax return. It's just like if you earn under a certain amount of income, you also don't have to file an income tax return. So a similar concept, if you own $1 million when you die, however it's titled, you are below the $5 million for now Maryland estate tax shelter, and you do not have to file a Maryland estate tax return. Um, do you want to
Sure.
clarify that
No,
anymore? Or?
well, I'm happy to jump in and just share some of I think the mistakes that we see because
Okay.
we see a lot of them. I actually started my career in a brokerage firm in the legal department and saw a lot of people whose beneficiaries no longer match their wishes. If there's
Mhm.
one thing people watching this today can do, it's verify the beneficiaries on all of your accounts and get them in writing. Don't assume that you've done anything. That's employee benefits, and not just your current employer, but prior employers. It's your life insurance policies, it's your IRAs or Roth IRAs. All of these items, all of these types of accounts have beneficiaries, and the beneficiaries listed on those accounts supersede anything in your will. So if you have what you would arguably call the perfect will and you've done it exactly right, but your beneficiaries don't match the will, the beneficiaries will supersede. and the asset won't pass under your will. There's lots of reasons to do that for tax reasons, especially if you're leaving money to a spouse, or especially if you have money that's subject to ordinary income tax like an IRA. So the biggest mistakes that we see, number one, are either not having a beneficiary at all, which is a tax nightmare and potentially a dispositive nightmare, but also naming the wrong person. You still have your ex-wife named on your IRA,
Mhm.
where you named your firstborn daughter, but forgot that you had two more kids, and it's too late once you've passed. So those are the big mistakes that we see. The other thing, you mentioned that you don't have to file an estate tax return if you're below the limit. However, because of the rules of portability and because of the some ways that you can use both exemptions that each spouse in a married couple has, a lot of times we suggest that folks do an estate tax return, even if the tax is zero, just because it preserves that amount of the exemption for the surviving spouse. The surviving spouse may not be anywhere near the current limit, but if the limit were to be dropped to 1 million or 2 million, they might
Mhm.
quickly get over that just based on having a house and an IRA, or they might inherit money. They might come into a windfall, and all of a sudden they're in a different position. So I think it's important to file the tax return almost always if you're a married human and you're widowed, because you just don't know what's coming down the pike for you financially. It could be remarriage, it could be any number of things. So that's what I'm gonna leave this slide at that, and we're gonna now show a slide with lots of numbers on it. And people sometimes glaze over when you see lots of numbers. So please don't do that. We'll do our best to walk you through this. Some of it we've already talked about. Helen, you talked about the federal and the Maryland piece and what those
Mhm.
rates are. But let's talk about ultimately just any details that you want to go into here, because I think we've covered a lot of this ground already.
We have, and one thing that you did point out, which, I also, wanna mention, and you're absolutely correct, when there is, when on these slides, you'll see we're talking about, for instance, 27.97 million for a married couple, 10 million per married couple. That is true. And that is one planning technique that we often use, and that's filing for portability. The good thing about filing for portability is that Maryland and the federal government have both eased up on the rules as far as the timing for that. When you actually have a filing requirement, you have to file an estate tax return within 9 months of date of death, or you can obtain a one 6 month extension period. When you don't have a filing requirement, but you want to file for portability, you have some leeway. You have up to 5 years to decide to file the return, which, you know, sometimes people just want to go ahead and get it done, do it. Sometimes people don't have that much money. They don't that they're dealing with the death and all of the other things that they have to deal with, and they're not ready to say that they wanna go through the effort of filing the estate tax return because it is cumbersome to put together. It's not an easy return to prepare, and they ask for a lot of information, and Maryland, um, is actually harder, if you believe this, with respect to the estate tax return than the federal government. Because the federal government, when you're filing for portability, which means basically, I'll back up a little bit, you can use both. When your spouse dies, if you file for portability, you get to keep the spouse's shelter to use for yourself. And so instead of having 5 million in the state of Maryland as your exemption, you have a $10 million exemption when you die if you filed for portability when your spouse dies. So you've kind of locked in that shelter, absent whatever your spouse used. Because if your spouse has given assets to someone else, like maybe your spouse left money to children directly, that decreases the amount that the spouse can port to, the surviving spouse can have access to. So when you're filing for portability, when you're filing a federal return, you can estimate the numbers because, especially if everything's been left to the spouse. They wanna know what you have, but they don't need you to get an appraisal. They don't need you to go through the detail that you would have to do for an actual required filing. Maryland wants you to. So Maryland does want all of the detail. They don't like you to estimate. Okay, I filed Maryland returns with estimates because they didn't tell us they wouldn't accept estimates until they were reviewing returns that had been filed. And then they said, "Oh, by the way, you need to give us better details than this." And I have, responded with the federal rules and, pointed out that we're allowed to estimate. And, that's just an ongoing thing because both the Maryland state, Maryland's, Maryland and the federal government have filing requirements. Maryland shelters below the federal government, so now Maryland reviews their returns themselves. It used to be that Maryland would accept it. If the federal government accepted your return, then Maryland would accept it. Maryland wouldn't accept it until after the federal government accepted it, but Maryland would accept it. Now Maryland reviews them. And so that does create a little bit of a disconnect.
Oh, yeah, I'm laughing because Maryland will do everything but a body cavity search when somebody dies to
Yeah.
find an asset. Can we talk real quickly, Helen, about which assets are includable in this? Because I think a lot of people assume that if all their property is joint, that they're using their exemptions, or if they leave everything to their spouse, that they're using their exemptions. And
Mhm,
there is such a thing as a marital deduction, which is different than an exemption. And all the jargon is can be
mhm.
frustrating for people. So the short answer is, if you're in this position, it's good to get professional advice because the jargon really is it's pervasive. But let's talk a little bit about the fact that if you're worth $100 million, you can leave all of it to your spouse and pay no tax at the first death. That doesn't necessarily mean that's good planning, though, because you may be eliminating the use of your own exemption. So I know that's a huge example, but am I missing something there, or is that also still part of the planning discussion?
It is part of the planning discussion, and so portability is a relatively new, not relatively new, meaning that 20 years ago, when I started practicing, it didn't exist. I can't remember now, it's been at least 10 years, probably more, since it came in, and when it first came in, it was introduced as part of a package that expired, and we didn't think it was gonna last, and we thought it would go away, and all of those things that whenever they say they have a permanent estate tax solution, I've heard that many times, and it's always changed. So, that's something I always take with a grain of salt, but portability was kind of a new concept, and there was something we used to always do, and that would be funding trusts. So one spouse dies, and the other spouse creates a sometimes people call it a bypass trust. It's also called a credit shelter trust, but they create a trust for their spouse, and the money in that trust bypasses tax in the survivor's estate. And that is still planning that is used. There's a lot of income tax implications as well that have to be considered. It's not something that I would get into, trying to figure out on your own. It's something that you really need to work with an attorney, probably an accountant, a financial advisor to try to figure out the best options for you. But that is still planning that is also very widely used, partly because if you um, instead of relying on portability at death, and I'm not saying you wouldn't do both, because you can always do both, file for portability and still fund the bypass trust. But if you fund the bypass trust, the money in that trust will grow, presumably, estate tax free. So you fund the trust when the first spouse dies. The surviving spouse may be relatively young, potentially could get remarried. All of the money in that trust will be protected in the event of a remarriage and will be protected. The growth will be outside of the surviving spouse's estate. Whereas the downside to portability is that portability, you get your spouse's 13 million shelter, 13,990. But that doesn't grow. That stays the way it is. If you file for portability in Maryland, it's a $5 million shelter and it doesn't grow. But meanwhile, you may have investments, assets that are going to grow. And if you're relatively young, then you may have 20 or 30 years of appreciation that is never, that's going to continue to grow much more than 5 million. So that's something that is a technique that's used. Trust planning for estate tax with married couples is very common. And also sometimes we plan for um, bypassing a child's estate. If you're all very successful family, you may not want your child may also have an estate tax concern on inheriting a large amount of money, and sometimes it makes sense to do something called generation skipping and skip your child's generation and leave assets in trust for your child's benefit, but in a way that it wouldn't be taxed in your child's estate. And those are all things that can be addressed and pre-planned for. A really good planning technique for trying to plan for an estate tax is life insurance. I did say life insurance is taxable. Traditionally, if you own the policy on your own life, that is taxable. If you could create something called a life insurance trust, the trust owns the life insurance. Many people with very large estates buy life insurance to fund the estate tax so that when they eventually have a tax due, the life insurance can pay it. And if the trust owns the life insurance, and if you don't own the trust or have any benefit from the trust, then that's a good way to keep the life insurance out of your estate, not taxed as part of your estate, and used to offset costs. Um, we
You
did
threw a
talk.
lot at us. You threw a lot at us there.
I know, I'm sorry. And you asked
No,
a
no.
small question.
Let me digest a little bit of that because sometimes it's nice to get two different perspectives. First, divorce proofing the assets that you leave behind, and what I mean by that is when you leave assets to your widow or widower, if you want to make sure that those assets stay in your biological or linear family, and to get to your grandkids or great grandkids you may never meet, the trust planning does make a ton of sense because it does divide not only from a tax perspective, but it also makes sure that you have some dispositive control over that.
Mhm.
I think trust can be used to protect against both creditors and predators. And a lot of times leaving money to kids, if you don't leave it in trust, the kids can be prey to either bad advice or the wrong friends or bad decisions or any number of things because maybe they're not familiar with how to handle that level of wealth. And it is a lot to handle once, people grow into it, that's one thing. But if it's sudden, you see a lot of lottery winners who wind up broke or
Yes.
athletes or others who have a huge income and no money, and it's because they don't know how to handle that. So that's number one. I would also say that I talk to so many people who are convinced that their kids are rotten and their grandkids are perfect in every way, and so
Mhm.
doing the generation skipping becomes not only good from a tax perspective, but again, it's a way to pass assets within your family tree down multiple generations. There are rules against perpetuities and trusts and some other things that you have to be cautious of, but for the most part, you can skip those rotten kids and go right to your perfect grandkids. And I say that because if you asked either of my parents, their kids are rotten, but their granddaughter's perfect. Lastly, you talked about life insurance trust, and I do think that life insurance trust can be powerful. They also can be used on married couples. So one way to use a life insurance trust is to have actually the insurance policy cover both spouses so that nothing is paid until both spouses are deceased. Naturally, that isn't available for the surviving spouse, so it doesn't replace the personal planning, but it will be a less expensive way to buy the life insurance that you might want to buy because the odds of a single death are much higher than the odds of two. And so the survivorship option becomes a much less expensive way if you're trying to prepay some taxes. If you're married, that is a much less expensive way to prepay the taxes with a trust. I want to make sure we move on because we are running toward the end here, and there's some documents that just about everyone over 18 should have, as far as I'm concerned. We have a lot of clients who, once their kids are 18, we say you got to do certain things because parental rights end at the age of majority. You can't even get your kids grades, even if you're paying the tuition in college, unless they give you permission. So you certainly can't do their banking for them or talk to a physician about their care. So, what are the things that folks need, regardless of their level of wealth, right away?
Um, yes, as soon as possible after turning 18, having a will, power of attorney, and medical directive are the three. necessary documents. As a parent, you're going to want to be able to make medical decisions for your child. And once they hit that magic age, you can't. You can't talk to their doctors. You can't get information. HIPAA privacy laws apply. And so I do a lot of planning for um, well, mainly it's when I do the parents planning and they start talking to me about their 18 or 19-year-old child that really comes to light, especially when the parents are divorced. Um, because the child can decide, maybe they make both parents their agent, maybe they make somebody else altogether, but they really should have those documents in place right away. Um, from the beginning, it's something that's very important. And no matter how much money you have or don't have, if you don't have a will, you're not saying what you want to have to happen to it. Naming beneficiaries is also important. Lots of people structure things so that they have beneficiaries on everything, they have joint assets, they don't think they need a will. And that may be true, except for those things that you don't think about. What if you die in a car accident? What if it's somebody else's fault and your estate can sue? And all of a sudden, nobody knows who's handling your estate or who should be in charge, and you haven't left those instructions. So, a very basic will is really vital, even if you think nothing is going to be covered under it. If that's the case, if you have everything set up perfectly, that's great. But at least you have the will as like a double insurance policy, making sure that no matter what, your wishes will be followed, even if there is something that will come under the will.
So Helen, I'm not a lawyer, nor do I play one on TV, nor can I practice without a license.
Mhm.
But I am a bossy thing when it comes to certain things, and so we recommend to clients that they talk to their attorneys about a couple of different things, and one of them is family communication,
Mhm.
and specifically about when you're naming responsible parties. I would strongly prefer not to see people name more than one. Especially when you see parents name all 3 of their children to make decisions for them, and I'm thinking to myself, when's the last time they could agree on where to go to dinner, much less on big life-changing decisions? So naming one person, but then having communication with the whole family and saying, "We're naming your sister because she's really good with money or because she's a physician and she can handle the medical things," or whatever it is. The communication is the key so there aren't hurt feelings when there are surprises. There's no surprise at the end. I'm naming these people to be responsible, which, by the way, is a huge job and not a lot of fun. But
Yes, and
go ahead.
often people name their oldest child or something. They think that that's the person. I really encourage people to try to think of their children's strengths and weaknesses and go towards that. Don't name John because he's the oldest. If he's a procrastinator, he's not going to get things done. You're going to want to name the take charge child, the one who's going to be able to get things done. Or the child with a medical background, if it's for your healthcare directive, you're going to want to name somebody who can do it, and not name
Absolutely.
somebody who's going to be the weak link and who's just not going to be able to do it. And I work with people all the time that probably had the parent thought about their weaknesses, or not only the parent. I mean, we're acting like it's only parents and children, and but whoever you name, if you're not naming somebody with those strengths, it's not going to be good.
Well, I would totally agree with you. And sometimes, if there's no obvious choice, you can also base this, especially the healthcare, on geography.
Mhm.
Which child is going to be most likely, or which named person is going to be most likely to be able to get to a hospital to talk to physicians on your behalf.
Mhm.
If you're in Maryland and one of your kids is in Delaware and one is in California, the one in California is going to have a much harder time getting to Hopkins, whereas the one in Delaware is going to be able to do that. And not that that's the only way, but if
Mhm.
both of them are equally capable, or heaven forbid, equally incapable, at least you have somebody who can get there. So I want to get to our last slide, and as we do, and we talk about these things, if you have any questions for either of us, there's a chat box. Hannah Dennis is behind the scenes. She will digest any questions that come in for either one of us or both of us. We're happy to answer them at the end, and we're also happy to do some follow up at the end, and we'll share some contact information as well. So while that's happening, some solutions. We talked a lot about problems. You brought up taxes. Really, this has been Debbie Downer, Helen. You talked about taxes. You talked about death by car accident. It's been pretty morbid. Let's talk about some things we can do to make things better, because gosh, that sounds like a more positive way to end today. You want to talk about asset titling?
Asset titling is really important. As you mentioned at the very beginning, and I always tell my clients in meetings too, it's really important to focus on how things are titled because that will control. If you have a joint account with one child, that child has the right to the asset at death. So how your assets are titled and how your beneficiaries are designated are very critical because those will control. And people forget. They name somebody, they name a parent, and then they get married. Uh, all kinds of things. So whenever somebody comes in to meet with me, we ask them to fill out a questionnaire and we ask them for all this information. And clients don't like to give it because they're like, why do you need this information? Which I understand. But we really need it because if we can spot these issues, we can help consolidate and get your plan to a point where it's actually going to do what you want it to do. Um, and
Yeah,
it,
and asset titling, when we talk about that, you mentioned if you have a joint account with your kid. So often we see a parent with 3 children and who's widowed maybe and will make one of the accounts joint for convenience,
Mhm,
which is essentially excluding the other 2 from that portion of the inheritance, which if it's a $5,000 checking account may not be the biggest deal, but which could be much more significant. And there are other ways to give one of your kids or others access to help you if that's what you want. One is with the financial power of attorney we talked about.
mhm,
One is you can be a trusted contact on various accounts. You can also, if you're concerned about leaving an asset under the will, you can also do what's called a TOD or a transfer on death and actually add a beneficiary to almost anything. In fact, the state of Maryland allows you to add a beneficiary to your car just to
I
make it
guess.
easier when the time comes. It's a I think it's what, $35 or something. It's nominal, but it's a way to have a beneficiary on your car because when we talk about asset titling, I almost always tell people don't own your cars jointly
Mhm,
because it subjects you to additional liability in the event that the primary driver's in an accident. It's not a game of perfect, but you want to make it harder for someone to suddenly say, "Ooh, my neck." Those kinds of things. So we talked about asset titling. We definitely talked about trust, and there are so many kinds. There's no way we can go through. We could do a 4 hour presentation on trust and still not be done.
mhm,
But the basic fundamentals, and I'm gonna use a layperson's terms, and then you tell me where I've misspoken. That the two primary types of trusts are one is revocable and one is irrevocable, which by its very nature means one can be changed and one can't. And then there's 100 flavors. It's kind of like saying this is yogurt and this is ice cream, and there's 31 flavors of each.
mhm,
Lots of different ways to do this for every different purpose. Some trusts, like a revocable trust, uses your social security number while you're alive, so it doesn't require a tax return. An irrevocable trust will have a tax ID, and therefore, if there's income of any type, you have to file an income tax return. There's a lot of pros and cons to these. Your estate plan doesn't have to be complicated to be terrific. The more complicated your assets become, if you're in multiple states, if you have multiple ex-spouses, if you've got a child with a health issue or a gambling issue or a drug problem or all the things that happen unfortunately in life, trust can be a godsend. You don't want to leave your kid so much money that he or she ruins themselves. I use the Billy Madison reference a lot, where you become the trust baby and you just no longer thrive. I mean, leaving a ton of money to a 22-year-old is not generally a good idea. I don't know about you, Helen, but when I was 22, I'd have messed that up 100 ways. Now I
like,
would be
it's
great
no
with it.
incentive. No
Well,
incentive to do things on your own too, that
not only
you
no
have
incentive,
the money.
but no acumen,
Right.
no network. Like
Mhm.
you get to a certain stage in your life where you know the right people and you sort of know how to handle it, hopefully. And at a given point, even leaving money to kids, you can set ages where they get principal.
Yes.
Give a third at 25, a third at 30, and a third at 35 with the hopes that when they get their first tranche at 25, if they make some mistakes, they don't make them again and again.
Exactly. Learn from the first mistake.
So, and then we talk about lifetime giving. Lifetime giving can be to family. One of the things we didn't talk about a lot today that I'm very passionate about is philanthropy
Mhm.
and ways to leave certain assets to your favorite charity or charities. And sometimes people go, well, I don't want to disinherit my kids to leave it to this association or that. That's where life insurance can play a role. You
Mhm.
can use the life insurance outside of your estate and leave it to your kids, but then have an asset that's in your estate that you leave to charity, so it's not counted in the taxable estate. It becomes an exception to that. So, if you leave an IRA, Helen, if you were my daughter and I left you an IRA, you'd have 10 years to spend the whole thing and you'd have to pay taxes on it. If I leave it to my favorite charity, they can take the cash, do anything they want with it, and pay no tax. So
Mhm.
you can amplify the amount of impact you can have on your community, on your family. You can do tax planning, legal planning, charitable planning, family legacy planning all together, and it requires a good attorney, a good financial advisor, and a good CPA.
Mhm.
Sometimes there's others, but generally there's your trifecta. And if you have those three people working together, pulling together to try and solve what you want to do, because there is no right answer. You can't walking into an attorney's office and saying, "Just write me a will you?" That's not how it works. You really do have to go through the questionnaire. You do have to talk about what's important to you, and that's true financially, and it's true from all these different standpoints. So we are ready for some Q&A. We talked about portability. We talked about life insurance. I know there's other things. Helen, you and I could talk for 6 days on this.
Yeah.
Hannah, are there any questions in the queue that we wanna go through, or should we start looking at closing remarks?
Yeah, I do have a couple questions here. Um,
Wonderful.
First one's regarding beneficiaries. Can you go over what beneficiaries are exempt from the Maryland inheritance tax again? And are there any types of assets that are also exempt?
You want first stab?
Sure. Um, Life insurance is exempt from Maryland inheritance tax, so that's another even with that, even life insurance owned by you, if you own life insurance and name a niece as your beneficiary, that is an exclusion to the Maryland inheritance tax. So Maryland, not Maryland estate tax, only Maryland inheritance tax. Um, Life insurance is excluded. The other, what was the other part of the question?
Basically, which beneficiary? So you talked about where it could be kids or grandkids, or a spouse. What about
Okay.
parents? What about siblings? Who's
Parents and siblings are also exempt.
okay?
Charities are exempt. So,
Mhm.
because they're charities, they do get an exemption from inheritance tax even though they're not related to you at all. Domestic partners are exempt from inheritance tax provided they have registered with the Register of Wills in Maryland that they're domestic partners. Spouses, of course, are exempt from inheritance tax. Um, step
Helen, does the beneficiary have to be a Maryland resident to be subject to the inheritance tax? If you have a niece in Maryland and a nephew in Delaware, are they both subject to Maryland inheritance tax?
If the decedent lived in Maryland, yes.
So it doesn't matter where the beneficiary is; it's where the decedent is in all cases, even though the inheritance tax is paid by the donee. Correct?
Yes, the inheritance tax is paid by the donee unless there's a tax clause in the will and there's money in the will, in which case a lot of times people say in the will that they want their estate to pay their inheritance tax, which
So
makes it
essentially, a
easier.
Delaware resident receiving an inheritance from their uncle in Maryland may have to file a Maryland inheritance tax return, even though they're not Maryland residents, just because Maryland overreaches that far.
It's actually a requirement of the personal representative of the estate to file the Maryland
Got it.
and it's called an information report and an application to fix inheritance tax, and that is done by the personal representative, and it's one of the required filings when you're working on an estate. So it's something that isn't necessarily filed by the beneficiary. Sometimes the beneficiary doesn't even know that they have to file it or that it's paid, especially if the will has a tax clause and there's money passing under the terms of the will.
So what about stepchildren? What about adopted children, or adopted the same as natural for inheritance tax? And what about stepkids? What about former stepkids if you're no longer married to their mom? How does all that work?
Stepchildren are exempt as well. Um, Adopted children are treated as if they're your natural children, and they are. So if you adopt a child, but the parent is still the birth parent is still in the picture, and if the birth parent leaves their adopted child something, actually that's not their child anymore. So that is one of those kind of funky rules. When you adopt
Hmm.
someone, you are their parent. Um, so there are a lot of exceptions. Some of them are a little tricky. Sister-in-laws, I believe, are still not exempt, even though sisters are. But that's one of those things that we usually would check once it gets to one of those things that we don't deal with as much. You just have to check the statute and make sure that you're right on it. Cousins, of course, are even um, less than less closely related than a niece or a nephew, so those are taxable people as well.
I
But
don't know. I'm pretty close with my cousins, Helen,
that's
just
true.
for the record, you know.
Some
All right, Hannah,
realize
other
good things.
questions? Other questions in the queue? I
Yep.
hope we tackled that one.
Yep, I've got another question. Are there plans to reduce Maryland estate tax exemptions in the future?
Always. I mean, Helen said earlier that she can't predict legislation, but if I know anything about Annapolis, it's that they're not going to be more generous with people they consider to be of means. They're going to be less so. So I would be shocked if we don't see it reduced. Helen, I don't know if I'm trying not to lean too political, but at the end of the day, I think it's absolutely easy and it's coming.
I'll have to tell you, one of the things that shocked me the most was when they raised it from 1,000,000 and increased it because it used to be 1,000,000. For many years, it was 1,000,000. They gradually increased it to 5 over a period of several years. I couldn't believe it. I never thought they were gonna raise it. If they dropped it, it wouldn't surprise me at all. It came up in the last session. It didn't pass. I was happy it didn't pass, but I don't know that it's not gonna come back. In fact, I wouldn't be surprised if it does because we're not in a good financial, situation in this state right now, and I might be, kind of sugarcoating that a little bit. So
Oh yeah.
everything seems like it's going up, and
Well,
I
yeah.
mean, all
I
the fees are going up, so estate tax, shelters going down would not surprise me.
Yes, despite being in a fantastic fiscal situation about a year and a half ago, it's now a train wreck. So I do expect that we'll see a grab at additional taxation, especially when it's taxing a minority of the people to benefit the majority of the people. I think it's low hanging fruit. It's easy to pass legislatively, and so yeah, I think we should plan if we're going to live in Maryland, and more importantly, if we're going to die in Maryland, we should absolutely plan as if that exemption is going to be lower or gone, and do the best we can with it because. I don't trust that it's going to stay at $5 million or 10 per couple. I just don't think it's possible.
Yeah, I mean, the only thing that might potentially give the legislature some pause is that there is a lot of movement. I meet with clients all the time who tell me they're not planning on staying in Maryland. And if they do decrease it with given our surrounding states and a lot of the other states having if they do have an estate tax at all, they have higher shelters. Um, and the reason that they raised it from 1,000,000 in the first place was because we were losing residents, and if you lose your tax base, you are in big trouble. So, hopefully, if there's any legislatures listening, please take this into consideration because
Well,
it's really important to keep the tax base, or else you have to raise the taxes even more and more
well,
heavily.
and you know that Maryland has just imposed what is essentially a leave tax too. Which I don't even know if that's constitutional, but to instead of incentivizing people to come here and businesses to come here, they're penalizing people for leaving by imposing a 6% tax essentially on the fair market value of a sale of a residence if you're not also buying one in the state.
Mhm,
There's a few exceptions to that, but at the end of the day, that is basically trying to penalize someone for trying to move for tax planning purposes, and whether it's legal or not, it's here. So,
mhm,
that's something else to be aware of. You have to decide you're gonna part with some of your assets just to leave, and like you, people are doing that every day. People it means. I mean, it's just, that is good planning, sadly, it's true.
mhm.
What else, Hannah? Maybe time for one more.
All right. I've got an interesting question here. It is, can a handwritten will be valid in Maryland?
Yes, provided you have 2 witnesses. It doesn't matter, that so a lot of some states will allow a handwritten will that doesn't have any witnesses, and that would be valid. That is not valid in Maryland. Um, but any will, if you do have 2 witnesses to your will, that is what you need for a valid will. Not 1 notary and nothing else, 2 witnesses.
So that means the cocktail napkin will can in fact be binding so long as two people also sign it?
Yes.
That's terrifying.
Yes.
But it's a great way to end the conversation. There's a free resource we're going to give out to everybody here. For anybody, pull out your phones, use the QR code. There is an ebook here. It is free, called "Estate Planning Isn't Only for the Rich," and this is something that I had written as part of a larger piece of work that we wanted to make available to anybody watching or listening to this today. So pull out your QR code or pull out your phone, use this QR code, download this information, and it talks about a lot of the things we talked about today from a layperson's point of view and a financial point of view. Again, I'm not a lawyer, so it's not legal speak. Helen, any closing remarks before we wrap it up?
It does seem like we were talking about a lot of estate planning for the rich, but considering how house values and IRAs and all of those things are taxed in your estate, it really, even worrying about estate tax in Maryland isn't just for the rich because those asset levels aren't. You could get there very quickly, especially if it drops to two.
So, my closing remark would be, if you have not reviewed your estate documents recently, and recently means a lot of things to different people. I would say at least every 5 years, or if there's a life change, a marriage, a divorce, a birth, a death, an adoption, something major, even a change of residence, frankly.
Mhm.
If you haven't done it in a while, pull it out, do that. Maybe talk to your counsel about it. Maybe talk to your financial and tax folks about it. If we stick this in a drawer and it collects cobwebs, it is more and more likely over time to not be what you really wish for and what you really want to have happen. So hopefully the call to action today, other than downloading this resource, is to pull out those estate planning documents. They're dusty, blow on them. There's a cobweb here and there, but pull them out, review them, make sure they still make sense, and if appropriate, contact Helen, contact your existing attorney if you have one, contact me or our office, or your existing financial advisor if you have one, and hopefully that would be a helpful next step. I'd be remiss if I didn't make all the lawyers happy. Here's a disclaimer disclosure. And with that, we are wrapped up today. Helen, thanks for doing this. I really appreciate it. I always appreciate your wisdom, your knowledge, and there's a lot to know. And I'm so glad I didn't go to law school.
And thank you so much for having me.
All right, everybody. Thanks for being here. If we can answer any questions, Helen is Helen's contact information. Hannah, is it on the initial slide? Do we have contact info? I
It
don't
is
know if we
on
do
the
or not.
initial slide, but it's also in the handout. Both of your contact information is on, the QR
Beautiful.
code, and will be
Beautiful.
following up with an email as well.
Beautiful. Thank you, Hannah. All right. Anyone who wants to reach us will have the information to do that. Thank you for joining us today. Hopefully, this has been informative. Hopefully, it hasn't been terribly depressing, and not everybody's reaching for the martini right now. But there's a lot to know, and for Maryland residents, we really have to be vigilant and aware. And so, thanks for being here today. Thanks again, Helen. Take care, all.
Thank you. Bye bye.